Robby, what's on your radar?
I want to tell a representative story about a woman named Alyssa, whom I recently interviewed and wrote about. 10 years ago, Alyssa landed her dream job, assistant director of the speech and debate team at James Madison, a public university in Virginia. She also became a faculty member of the School of Communication Studies, where she met a student named Katie. Katie took Alyssa's speech class in the spring of 2013. The two quickly became best friends, and the following year, Katie graduated from JMU and accepted a teaching position there with the speech and debate team. The pair worked closely together as friends and colleagues and traveled for events. One night, during a trip to New Jersey for a forensics tournament, Katie told Alyssa that despite being in a relationship with a man, she was a lesbian and had developed feelings for her, according to Alyssa. Though initially reluctant to put their friendship at risk, Alyssa says she eventually came to reciprocate Katie's feelings. And they ended up dating for 2.5 years, living together for much of that time. Well, the relationship ended badly, causing both women much consternation. Almost a year later, on December 4th, 2018, well after the relationship was over, Katie filed a complaint report with JMU about Alyssa. This report then became the basis of a sexual misconduct investigation, and Alyssa was accused, not by Katie, but by JMU, of engaging in a non-consensual relationship with her former girlfriend, according to Alyssa. Alyssa was astonished and horrified by all this, not least of all because the university had already said their relationship was perfectly appropriate. They were not in a teacher-student or mentor-mentee relationship. But JMU's administration now saw matters a different way. They suspended Alyssa from teaching and ordered her to appear before a tribunal. Importantly, they did not let her read her ex-girlfriend's complaint beforehand. She went into this hearing, a trial really, with no idea what she was even accused of. Despite the situation, she was prepared to defend herself and to question her ex during the proceedings. That's what happens in the courtroom, right? Defendants have a right to confront and question their accusers. This is a foundational aspect of our justice system. Well, Alyssa's ex didn't even attend the hearing, which made it difficult for her to defend herself. Now, she might have benefited from advice from a lawyer, but JMU policy prohibited lawyers from attending sexual misconduct hearings.
I was not given information by JMU what the allegations were until 3 months after my Title IX case started. I wasn't given information on what the actual case against me was until I had already been suspended by the university for teaching, but I was given this redacted paperwork and she never mentioned non-consensual relationship. It was sort of implied and inferred by the Title IX office. So that was my first real cue that something was fundamentally wrong in the due process I was being given by James Madison University.
Ultimately, Alyssa was found responsible for being in a non-consensual sexual relationship. Think about how ridiculous that is. This wasn't a hookup gone wrong where some boundary of consent was crossed. The pair dated for years. How could JMU see an ongoing relationship between two women who at one point loved each other as anything but consensual? Nevertheless, the administration made it impossible for Alyssa to keep teaching, and so she left. She was hired at another university, sold her house and moved, but when her new employer found out about the sexual misconduct finding, the offer was abruptly rescinded. Alyssa told me all this during an interview I conducted with her, and you can read that full article at reason.com. I also interviewed her attorney, Harriet Hagman, of the nonpartisan New Civil Liberties Alliance. I sought comment from Katie, the ex-girlfriend, as well as JMU officials. Katie did not respond. JMU declined to comment. With Hagman's help, Alyssa is suing JMU for violating her rights, and I certainly hope she prevails. This was a miscarriage of due process, a violation of basic fairness, and one that has really irrevocably harmed an individual. So I hope she gets justice. But here's the thing, Alyssa is not alone. In the last 10 years, hundreds of people who lived and worked on college campuses have been fired or expelled for sexual misconduct following similarly unfair proceedings. I've covered dozens of these cases, and each of them is more outrageous and unfair than the last. Many of the maligned persons have sued and eventually prevailed because when judges get involved, they find the elements of these hearings to be so confounding. In a 2018 decision, for instance, the U.S. Court of Appeals for the Sixth Circuit ruled that the University of Michigan had wrongly prohibited cross-examination and must provide opportunities for the accuser and the accused to question one another. Now, why is it like this? Well, the culprit in one sense is Title IX, a federal statute that mandates sex and gender equality in schools and has been vastly expanded over the last 2 decades, not by legislators, but by administrative fiat. In 1972, when Title IX originally became law, its purpose was to compel schools to add athletic programs and clubs for young girls. Alyssa's attorney, Harriet, told me she was in school in the 70s and was actually grateful for the law back then because the opportunities she was able to enjoy because of it. Today, it's applied in a completely insane way. Title IX is a very simple statute. You read it, you know what it means, Harriet told me. It has been turned on its head. It has been used in such a bizarre way. Schools and universities are simply not equipped to move forward with these kinds of life-altering proceedings, end quote. That's the fault of the U.S. Education Department, which pushed colleges and universities to adopt unfair sexual misconduct adjudication policies during the years of Barack Obama's presidency. Under Obama, the Ed Department decided that Title IX required not just equal treatment, but systems of unfair investigations in kangaroo courts aimed at rooting out sexual harassment and misconduct. The federal government exhorted campus officials to vigorously prosecute sexual misconduct, define it broadly, and give accused persons very little recourse. The department discouraged cross-examination, the presence of attorneys, and even the involvement of juries. The government preferred a single investigator model under which a lone official would investigate a complaint, decide what the charges would be, and then rule on them. Can you imagine? It's insane, but this was the norm on hundreds of college campuses for years. Then, under former President Donald Trump, Education Secretary Betsy DeVos rescinded the Obama-era policies. I'm sure a lot of people watching this right now are skeptical of DeVos and some of the things she did while she was in office. But trust me when I say that this was a vitally needed reform that made basic fairness a central component of Title IX adjudication once again. Now, that change went into effect a year ago in August of 2020. But now Joe Biden is president, and he has selected a woman named Catherine Lehman as his Title IX czar. This is gravely concerning because Lehman had the exact same job during the Obama years. That's right, Lehman was the enforcer of all that unfair guidance. No single government official bears more responsibility for creating this Kafkaesque legal regime than Lehman. And Biden would like to give her back her old job. In July, Lehman appeared before the Senate Committee on Health, Education, Labor, and Pensions and was scrutinized about her views. Here's what she said when she was asked about basic fairness for the accused.
When I met, you told me that you've been painted as someone who only believes victims, but that you didn't agree with that. Would you support keeping a presumption of innocence requirement in the current Title IX rule if the Title IX rule is changed?
And again, I'm trying not to over-lawyer, but there isn't a presumption of innocence in the existing Title IX regulation.
Did you hear that? Lehman does not believe that the adjudicators in these proceedings should grant the accused the presumption of innocence, the most basic and fundamental aspect of any fair quasi-judicial proceeding. Later during her questioning, Lehman eventually conceded that adjudicators should merely be open to the possibility that an accused person was telling the truth. In part due to her less than stellar commitment to the principles of due process, the committee deadlocked on whether to advance her nomination, leaving her fate in the hands of Majority Leader Chuck Schumer. Now that the chamber is back in session, Schumer could call for a motion for a full Senate vote on her confirmation. Obviously, the Senate has plenty on its plate right now, and frankly, we should all hope that Lehman's nomination gets lost in the shuffle. This is someone I had written about the guidance that she was putting out for years, and I was very surprised to see, again, she's been appointed to the exact position she held, Assistant Secretary for Civil Rights in the Education Department. And there was just, I know, obviously, victims, we have to support them, and they deserve to be supported and listened to, and there's certainly has been a sexual misconduct problem on college campuses. But when you see things like the case I just outlined for you, a relationship that ends badly and then ruins someone's life because of this ridiculous judicial proceeding, I do not want to bring back these kinds of things. What do you think, Kim?
Well, we do have to protect victims, so I understand why people want to sort of, because one of the issues that we were having and what we were seeing was that when a student would accuse another student, then the accused would suddenly be, I believe, even expelled or suspended from classes and wasn't able to attend, even though they hadn't proven that person was actually guilty. And so There was this idea that an accuser could just retaliate for any reason whatsoever if they just didn't like that person or, a soured relationship or whatever. And we certainly do need to have a presumption of innocence. But at the same time, the problem was in many cases, I would imagine even maybe the majority of cases, where a female student or maybe even the faculty they have a real situation, and yet they're still forced to go to classes with the person who assaulted them or harmed them in some way. And so we have to have some sort of balance where we can protect everybody. I mean, we're seeing this even with let's say the gymnasts, right, and the Nassar case, where they said, hey, this person's abusing us. And it took an investigation 3 years before they actually did anything. And he was able to abuse 70 more girls before they did anything. So, it's that balance, I think. But definitely, I do believe in due process. But how do we protect people at the same time?
Right.
Ryan, what do you think?
Yeah, I mean, I think when it gets out of balance that it actually is the survivors who end up suffering. Because if people lose faith in the credibility of the system that is adjudicating these disputes, then survivor justice is harmed, because people will always question whether or not there was integrity in this investigation. So if you get people believing in the process again, that there was due process, that this was investigated fairly, and the conclusion was X, then that actually benefits survivors in a lot of ways and can contribute towards some sense of closure and some sense of resolution to the to the traumatic affair. Betsy DeVos, I think, is one of the most destructive and malevolent forces in our public life. And I actually edited a book about her called Schoolhouse Wreck. I think there's very little decent to say about her, but I do think that her Title IX reforms were much closer, to where it ought to be than what had been in place previously.
Yeah,
I agree with that as well. Yeah, and I know.
I was just a part of it too is when there's a dispute of sexual nature between students. Sometimes even the victim, the accuser, doesn't actually want this full kind of trial. They want some kind of restoration or reconciliation process with the person. They don't want to do this kind of confrontational thing. But because of the way Title IX was interpreted, it was not on them. It was the university had to move forward in this way, because of the guidance they were getting from the federal government, sometimes contrary even to the victim's wishes, and that didn't make any sense. So the new guidance was that, well, if the students would rather work it out in some guided sort of restorative process, isn't that better? Shouldn't we do that? And
something people should know is that when Alex Morse was accused by these anonymous college Democrats during his primary challenge to Richard Neal, there was no specific allegation and there was no person making the allegation. Yet UMass Amherst still opened a Title IX case and went through the entire case. They acquitted him because there was nothing to find there. They invited him actually to participate in this. He was like, well, if you have an allegation or a person making an allegation, then tell me. But I'm not going to dignify these proceedings unless you do. Separately, if you start involving an administration in disputes between people who dated for 2.5 years, like you talked about, you set up a dynamic that's actually similar in some ways to Afghanistan, where the U.S. was able to kind of adjudicate disputes, and so you would have factions within Afghanistan who, instead of dealing with the situation through processes that existed, like today we have civil courts and we have criminal courts if there are things that need to be adjudicated in that way. But instead of doing that, they would go to the U.S. and say, this person's Taliban, or this person's Al Qaeda, and then the U.S. would drone them.
Yeah.
And so so if you give people that option, some jilted people are going to take it.
Yeah, and the Morse situation you brought up is a really good example of the weaponization of this process.
Right.
Yeah.
Right. And then that undercuts what survivors need, which is credibility in the process. Sorry, go ahead.
Let's hope we don't start droning the accused.
Right. Metaphorically, though, it seems like
we kind of
Yeah. But next on Rising, Katie Halper joins to discuss Gymnast's disturbing Senate testimony on the FBI's investigation into convicted sex offender Larry Nassar.